Okay, so let's talk bankruptcy. Bankruptcy is one of those topics that I think gets a bad rap, so to speak. It's seen as something that's really negative, but we actually need bankruptcy in a free market economy, and here's why. Back in 2004, the World Bank did a report called Doing Business. It was so successful that they've done it every year since. And in doing business, what they did was they looked at the factors that lead to successful economies. So things like how easy is it to get a business license? In California or in the United States, you can get a business license and be operational in your business within a few days. In France, for example, it takes about a year and a half. How easy is it for it to hire and fire employees? And how easy is it for you to get access to funds to start a business? So all of these factors. One of the factors was bankruptcy. And the reason why bankruptcy is an important factor in determining a successful, in helping to measure a successful economy, is that people, entrepreneurs, need to be able to start and exit businesses quickly. They need to be able to, when things aren't working out, be able to dissolve the business so that they can start over. And so bankruptcy is one of those factors that we need in order to have a healthy economy. And there have been lots and lots of major businesses that have filed bankruptcy and come through it. American Airlines, United Airlines, the WWE. Donald Trump has had, I think, 6. And so bankruptcy is one of these tools that businesses and individuals use to help reestablish themselves after a bad financial or series of financial experiences. One of the things about bankruptcy is we don't look at the cause of the bankruptcy, we just look at the process of filing bankruptcy. What is bankruptcy? Bankruptcy is a legal process that provides relief to individuals or businesses, known as debtors, who cannot repay their outstanding debt. It allows debtors to reorganize or eliminate their debts under the protection of the federal bankruptcy court. So bankruptcy is federal and not state. When you're filing bankruptcy and dealing with bankruptcy, you're dealing with the federal court system. There are many types of bankruptcies, but there's 3 types that we're going to talk about today. Chapter 7, which is liquidation, Chapter 13, which is individual reorganization, and Chapter 11, which is reorganization for businesses. Chapter 7 simply means that everything is dissolving. The business is not continuing. For an individual debtor, that means that they are wiping all of their debts away in order to start new. Reorganization is where the individual or the business proposes a plan to repay back some of their debts and to keep some of their assets and return some of their assets or dissolve some of their assets to help pay off their debts. So prior to 2005, it was super easy to file bankruptcy. And you could file Chapter 7, run up a bunch of debt, file a Chapter 7 bankruptcy, have all of your debt wiped away, and then go file another bankruptcy. What happened in 2005 was that Congress enacted the Bankruptcy Abuse Prevention and Consumer Protection Act, or BAPCA. And it proposed some really important reforms to U.S. bankruptcy law. And the first was a means test for Chapter 7. Chapter 7, again, liquidation. And so the means test basically said that in order to qualify for a Chapter 7 bankruptcy, you had to financially qualify, meaning that your individual income had to be below the state's median income. And if your income was higher than that, then it pushed you into Chapter 13. And really, it pushed most people into Chapter 13. Before filing bankruptcy, the debtors have to complete a credit counseling course approved by the court. This is commonly known as consumer credit counseling. So you have to do that before filing the Chapter 7 bankruptcy. Also, after filing, the debtors have to complete a financial management course to learn how to better control their finances. There were stricter filing requirements, so you couldn't continually apply for Chapter 7. I think it's one every 7 years now. I could be wrong. And There is, in the bankruptcy process, what's called an automatic stay, which as soon as you file bankruptcy, your debtors can't be calling and bugging you for repayment for a certain amount of time. The BAPCA put a limitation on that automatic stay for folks who are repeat filers of bankruptcy. So the impact of the Bankruptcy Act was fewer Chapter 7 filings. Like I said, most people now are funneled into Chapter 13. Higher costs and documentation requirements. So because of the changes to the system, it's actually more expensive and more complex to file bankruptcy now. And it also created some protections for consumers. For example, the requirement for credit counseling and the requirement by financial education. Hopefully, by filing a Chapter 7 bankruptcy now, you learn not to get into the same problem again. So your bankruptcy case, again, is federal, and the petition is filed in bankruptcy court. And generally, you have to list all of your debts, all of your assets, all of your income, and all of your expenses. All of your financial information needs to go into your bankruptcy application. Very important. If you leave something off, that is an asset. It can be deemed as fraudulent. If you leave off a debt, then that debt will not be wiped away in the bankruptcy process. Upon filing, what's called an automatic stay goes into effect. The automatic stay prohibits creditors from pursuing collection against you for 90 days. In a Chapter 7 and a Chapter 13 case, once you have filed the petition, a trustee is appointed to oversee your case. And so what the trustee does is they are responsible for liquidating your assets and distributing the proceeds to your debtors in a somewhat fair manner. In a Chapter 13 case, they manage your repayment plan, and they also hold what's called a 341 meeting, which is a meeting of your creditors where they can question the debtor, or you, if you're the debtor, under oath about your financial situation and the accuracy of the bankruptcy petition. In order to receive payment, so if someone owes you money and they file for bankruptcy, the first thing that you need to do is file a claim. And so you file a proof of a claim that basically says, yes, this person owes me this much money, and this is the collateral that I have that secures that debt. Or this person owes me this much money and I don't have any collateral. Remember that if there is collateral, you are a secured creditor. If there's no collateral, then you're unsecured. And when we look at who gets paid when, secured claims come first. So the trustee, generally the people with secured claims or the organizations with secured claims get the collateral back. And then we go to unsecured claims, which are priority unsecured claims first. So taxes, child support and alimony, or spousal support now. And then the rest of the general unsecured claims. So credit card bills, things like that. Generally, unsecured claims are paid last. And if you are an unsecured creditor, you generally get pennies on the dollar. There are certain debts that are exempted from your bankruptcy. The first is a homestead exemption. Generally, you have some protection for your primary residence if you are a homeowner. Every state, so there's a federal list of exemptions and a state list of exemptions. Every state is different. So for example, in California, the homestead exemption is I think like $25,000 or $50,000, where in Florida, the homestead exemption is your home is exempt. If you are not a homeowner and you are a renter, there is a separate list that you can choose from that has no homestead exemption, but it exempts your retirement account. And so exemptions are different for each state. They're different federally. You choose between the state and federal. And for some states, there are like list A or list B, and you choose from list A or list B to see which one makes sense for you. There are certain debts that can be discharged in a Chapter 7 filing. Current credit card debts are generally discharged. Medical bills are generally discharged, and personal loans are generally discharged in a Chapter 7 filing. There are also debts that are non-dischargeable, meaning that you will remain responsible for those debts even after filing bankruptcy. In most cases, student loans are not dischargeable in bankruptcy unless you can prove undue hardship, which is very, very rare, or if you can prove that the institution that you received the loan to attend was fraudulent in the way that they provided or what they promised you in delivering your education. Child support and alimony, certain types of taxes, and any court-ordered fine or penalty is also not dischargeable in bankruptcy. So let's talk about the debtor's estate. The debtor's estate is basically all of your assets, everything that you own at the time of filing. So it typically includes any real estate that you own, your personal property, your bank accounts, and any business interests that you might have, your investments, things like that. Exempt property is excluded from the estate, meaning that it cannot be liquidated to pay creditors. And then certain assets acquired after filing are also exempt. So your wages, for example, once you file bankruptcy, the automatic stay goes into effect, and then you are still at your job. The wages that you earn after filing for bankruptcy are yours to keep. In a Chapter 7 bankruptcy, the trustee liquidates non-exempt assets from the estate and then distributes those proceeds to creditors in that secured, priority unsecured, and then unsecured order. So what is the trustee responsible for? Well, first of all, they have to sell the property for money. Their job is to manage and close the estate as expeditiously as possible, as is compatible with the best interest of all the parties. So, and what that means is if it makes sense for them to sell an asset in 6 months rather than today, they will sell the asset in 6 months rather than today, because they want to do what's ultimately going to get the most return for the creditors. If there is an issue with the debtor's financial affairs, if a creditor, for example, thinks that there is an asset that the creditor is hiding or that the debtor is hiding, it is the trustee's job to go and investigate that stuff. It's also the trustee's job to examine the claims that are filed by creditors and reject the ones that are improper or shouldn't be paid out of the bankruptcy. The trustee also has the ability to oppose the discharge of debt. When doing so makes the best sense to the trustee. Generally, the trustee is somebody, they're court appointed, so they're generally an attorney or a retired judge. This is somebody who's very familiar with bankruptcy law and the legal system. It's also the trustee's job to furnish the creditors with information about the estate and their administration of the estate, unless the court orders otherwise. Sometimes the court may order the filing to be sealed for some reason. The trustee's job is also to file the tax reports, and the trustee then files, once everything has been distributed, a final report and file it with the court. Sometimes you file for bankruptcy and your bankruptcy case is dismissed. What dismissed means is that the court has decided that they're not going to take up your bankruptcy and you need to go figure out how to pay your bills on your own. Grounds for dismissal include failing the means test that came out of the Chapter 5 or the 2005 legislation. If you have committed fraud or misrepresentation in your listing of assets, so if you understated your income, if you lied about something or transferred an asset out of the bank just before filing bankruptcy, so that maybe you're trying to hide it. If you fail to complete all the required courses, fail to appear at the 341 meeting, or abuse of the bankruptcy system are all grounds for the court to dismiss your case. Once the estate has been distributed among all of your creditors, the court will allow the debtor to be discharged except for those non-dischargeable debts. Moving on to Chapter 11 and Chapter 13, both of those, remember, focus on rehabilitation and not liquidation. Chapter 11, the filer of a Chapter 11 is known as the debtor in possession. There is no trustee in a Chapter 11 case. What they do is they file as a debtor in possession. They are responsible to get their creditors together to create a creditors committee, and they come up with a plan of reorganization. The creditors have to approve the plan of reorganization. They can also submit their own plan of reorganization. Generally, what that looks like is something along the lines of a payment plan in order to pay back the debts that you owe. Many times, especially with large bankruptcies, I'll use American Airlines, for example. They came out of Chapter 11. I'm trying to remember when, but it was relatively within the last few years. One of their largest creditor groups was their pilots union. So they signed over airplanes to the pilots union in order to help satisfy that debt. By signing over the airplanes, the pilots now had the rights to those assets, and they also were paid back. So it's like, here's some assets, and then we're going to pay you this much, and we'll do this for 5 years, and then we'll all be paid off. That's typically what a plan of reorganization looks like under Chapter 11. The plan is confirmed by the court, and then once the bankruptcy once everybody's agreed to everything and the debts have been paid off, the bankruptcy is then discharged. Sometimes that's a few months, sometimes it's a few years, but generally there is a time frame within which the court says is acceptable. Chapter 13 is an individual rehabilitation. First thing to know about Chapter 13 is that your creditors cannot push you into Chapter 13. With Chapter 7, your creditors can push you into a Chapter 7 liquidation. With Chapter 13, a plan of payment is proposed by the individual, and basically what that means is that they will make payments to pay off some of their debts. They have to promise to pay all of their secured and priority claims, and then all of the other remaining classes have to be treated equally. So if I'm going to pay off 30% of my credit card, I'm going to have to pay off 30% of the other unsecured claims as well. I don't get to pay off none of my credit card and then some of this creditor and some of that creditor. Everybody gets treated equally once you get to the unsecured level. In order for the court to confirm a plan of payment under Chapter 13, the creditors have the opportunity to voice their objections to the plan. Unsecured creditors have to receive as much as if they would if the bankruptcy was liquidated under Chapter 7. Plan has to be feasible. You have to be able to pay within 3 years, and the debtor has to act in good faith. Once that happens, the debtor is washed clean of all pre-petition debts except those that were addressed in the plan. And then unlike Chapter 7, those debts are not permanently discharged. They're paid off over a period of time. Short and sweet for bankruptcy. What'd you learn? What'd you take away? Think beyond the topic. Maybe look into some corporate bankruptcies. It's actually really kind of interesting. And think about how some of that can apply to your life.